This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So what I did then was I'm bringing what I'm looking at here is this tweet to Jukin Media, who had, I think they had replied or something. Oh, they said we left a comment on the video.
Yeah.
And we'd like a chance to respond to this. It's important to understand that we provide a service, licensing and all that. That's fine. We specialize in viral style videos. You can get a license for $49 on the website very quickly. I think that's actually quite a fair price. I've seen prices, and I've sent demand letters for around $300 or $400 for these kinds of things instead of $49. So I think $49 is actually a really fair price.
Why wouldn't their actual damages be $49 then?
Well, they might actually have the actual damages be $49. Well, I'm less concerned about the actual damages, and I'm more concerned about when they get attorneys involved. The attorney's fees are going to be at the reasonable market rate, which is around $250 to $350 an hour. And that's going to add up quick. And smart attorneys who have billable hour requirements are going to run up those hours quickly by doing all the work they need to do right away. And it's not illegal to do that. That's totally normal. You want your attorney to do all the work ahead of time. It will probably save you money in the long run. But if you can figure it out before you get there, that would be even better. Like if they could figure it out now. So they say, in effect, you, MXO, are taking other people's videos without asking them, posting them to your channel, and making money off of them. You could simply pay a modest $49 license fee to use our videos. We're happy to discuss the situation and try to come to a reasonable solution. We're willing to discuss some kind of longer deal so that you have access to our entire library of videos. We never want to issue copyright strikes. We have a duty to protect the copyright of creators who have signed with us. There's no reason we can't work together. And so you have access to amazing videos, and those creators share in the economics. I'm actually okay with that response. That's actually a really okay response with me. But I still wrote back and asked them how they understood fair use. Just, I gotta poke the bear a little bit. I'm a defense attorney, and it doesn't look very good if I don't stand up for people, even when I'm not representing them, just to stand up for the situation. So I asked them about fair use. And Legal Eagle replied, pointing out that Jukin has been to court before, and then I looked up that court verdict, and there was no verdict. The jury verdict is sealed. Instead, they settled before it got to court. And so I pointed out the judge said, did equals 3, which was the user of the videos, did equals 3's episodes, which undisputedly use graphics and narration to tell jokes about the events depicted in the videos. Did they criticize these videos, which were themselves made to serve the purpose of humor and entertainment, or did they simply point out the inherent humor in these videos? And we got a response then from Jukin Media. We consider fair use in these matters, and we disagree strongly that this constitutes fair use. As you've mentioned, we fought in court over similar usage in the past. And then they point to an article, and I said, thank you for your response. It's a tough case, and I hope that this can be worked out, because otherwise it's just going to be an attorney payday. So then what I thought we could do today is go over the actual equals 3 case. It is 18 pages long, and I know I've been accused of just reading court cases before, but there's a reason why I just read court cases. You ever hear of an audiobook? Sometimes people just want to hear what's going on. So I'm going to try and condense it a little bit, but we're still going to go over the major parts of the equals 3 versus Jukin Media case. The only order coming from the judge in this case, because it was settled before a jury verdict, the only order is a partial summary judgment order. And this is probably not very precedential, if precedential at all. This probably cannot be used for much more than to point out to a judge, especially a judge in the Central District of California, and especially this judge. You probably can't use this for much, but you could definitely cite it and say, this is what happened in this case, and we'd like you in another case, judge, to use this same sort of logic. And that's a perfectly valid way to use this. So this is the equals 3 case, order granting in part and denying in part Jukin Media's motion for partial summary judgment. Equals 3 LLC is the company that was hosting or making videos on YouTube that were allegedly using parts or wholes of Jukin Media's licensed videos. And Equals 3 got a demand very similar to the one that we saw in the MXO Plays things that we saw yesterday. And their response was for Equals 3 to go to court. And then Jukin Media, as the defendant, filed counterclaims for 19 videos. And the judge writes, "This copyright action centers around funny videos and presents issues that are anything but simple. The instant motion, the summary judgment motion, requires the court to evaluate whether a humorist's use of viral videos is a fair use." Sounds awfully familiar, right? This complicated inquiry requires this court to make distinctions along the fuzzy boundaries between commenting on humorous videos in a transformative manner and simply exploiting them for their inherent humor without paying the customary price. On November 21st, 2014, plaintiff and counterclaim defendant Equals 3. So there's some strange language for you. Plaintiff and counterclaim defendant. So try to forget that second part. Just we'll say plaintiff Equals 3. That they've been sued back by Jukin Media and the same thing. That's what counterclaim defendant means. So even when lawyers find that stuff, we have to start like writing in the margins, like, okay, who's the counterclaim plaintiff? Who's the counterclaim defendant? Eventually you do get it without having to write it down, but it takes a long time. So just like disregard that for a moment. Plaintiff sued defendant. Equals 3 sued Jukin Media for a declaratory judgment. A declaratory judgment means we're asking the judge to say this is not copyright infringement or you own your video or something like that. And they wanted relief under 512F of the Digital Millennium Copyright Act, which prevents fraudulent use of DMCA takedown notices, or the way I like to phrase it, it prevents knowing misrepresentations. Jukin counterclaimed, asserting that Equals 3 infringes 19 copyrights. Presently before the court is Jukin's motion for partial summary judgment. It's granted in part and denied in part. That doesn't help anybody. That means you got to, whenever you see that, that means you got to keep reading. Jukin is a digital media company that amasses a library of user-generated internet video clips to license on creators' behalf. They employ a research and acquisitions team of 11 people to scour the internet for videos likely to go viral or become sensationally popular. Jukin's employees then locate the video's creators and enter licensing agreements with them. Jukin has a library of over 17,000 short-form videos, which I think they just said was 60,000 now. And who knows, they might employ more than 11 people by now. This was back in 2016. Jukin uploads these videos to its YouTube multi-channel network, MCN, and to Jukin's own content-focused websites. Jukin uses these videos to create digital productions, which Jukin distributes on its MCN and websites. Beyond arguing that these productions are original, Jukin does not offer evidence regarding the precise nature and content of these digital productions. They monetize the videos via ad-supported or subscription-based third-party syndicators, which take responsibility for content distribution. Media partners pay for sponsorships. They promote their videos and license them for traditional media platforms such as television and cable. Jukin's partners include the Ottah FAQ show and the Young Turks, which Jukin describes as YouTube shows that are similar to Equals 3's show. Equals 3 does not dispute the fact that Jukin's partners include these two shows, but argues that the shows are distinct from theirs. In support of this argument, they offer the declaration of its executive producer, Kadiato Martin. Martin states that The Young Turks is distinguishable because it's a politically charged news and current events show, and the FAQ show is distinguishable from Equals 3 because it's in Spanish, plays viral videos one after another in no particular arrangement, and offers few remarks. That's going to be critical here. Equals 3 produces short humor programs which it broadcasts via YouTube. Its humor programs typically involve a host who gives an introduction, shows parts of video clips, which are usually shown in edited form and inset with a decorative graphical frame, and remarks about the events and people presented in the clip. In each episode, quote, "The host weaves an originally crafted humorous story theme throughout the episode using multimedia content, text, graphics, and animation, sound effects, voiceovers, and video clips to enhance and develop the story. Often portions of the viral video are shown more than once during a single Equals 3 episode." Oh, that's critical. Shown more than once. The host will frequently offer an originally authored monologue, will provide spoken and performed commentary on the various video clips, including facial expressions, sarcastic remarks, derisive commentary, sexual innuendo, and social commentary directly targeting and referencing the people, events, and circumstances depicted in the source videos. This sounds awfully familiar, doesn't it? Each program is roughly 5 minutes long and typically features 3 segments, each of which centers around a different video. Equals 3 also offers its executive producer's declaration that stylistically, the E3 episodes feature frequent jump cuts and are edited to appeal to fast-paced tastes. Equals 3 typically obtains source footage for its show by scouring the internet for source videos. Jukin argues that E3 directly targets its videos but fails to offer any evidence. It is undisputed that E3 uses portions of Jukin's videos without paying a license fee. Each of the subject source clips from Jukin is a user-generated video featuring either a slapstick-style mishap, an animal in a humorous situation, or simply a cute video of an animal such as a dachshund chasing a crab on the beach. These are the videos in the equals 3 dispute.
Is the judge in the analysis here saying that these are cute, or is that original language from one of the parties?
Those are from the Ramos Declaration and the Martin Declaration. So the judge chose to quote those. So you can at least believe in that. The judge liked that language enough that they used that language instead of writing it out on their own. It is undisputed that each of the allegedly infringed Jukin videos was published before Equal 3's alleged use of that video. And on that note with your question, the reason why he's quoting so much is this is a summary judgment motion. So he wants to show what and I don't even know if the judge is a man or a woman. The judge wants to show whether this is whether these are undisputed statements or not. Because remember, the summary judgment standard is that there are no disputes over material facts. So if there's a dispute over a material fact that is good for a jury to decide, that can't be decided on summary judgment. Summary judgment is only appropriate when the moving party is entitled to judgment as a matter of law, which the sort of implied part there is that the facts then are undisputed. If a fact is undisputed, then how do the facts operate to the law, or how does the law operate on the facts? And then if that law operates that one party wins, that's summary judgment. On March 12th, 2014, E3 host Ray William Johnson announced that the E3 show would be going on hiatus to find a new host. When Jukin heard that E3 was to resume its broadcast, they contacted Equals 3 to inform them that any use of Jukin's videos would be considered infringing. Jukin's letter indicates that Jukin is willing to negotiate a license agreement and indicates that E3's willingness to link to and credit Jukin's content is not sufficient. So there you go. Just linking to the content it's actually the opposite. That would tell me as an attorney, well, then you knew that you were using someone's video. It wasn't just like, oh, we can't find these people. We know exactly who the owner is and we're choosing not to pay a license fee. So I mean, if you're in the right, great. But if you're in the wrong, now I have a knowledge requirement or evidence of knowledge that I can use against you. It is undisputed that no license agreement resulted. July 16th, 2014, E3 resumed broadcast, published an episode called The Resurrection to YouTube. The Resurrection used Jukin's video Black Bear Milk Bottle Rescue. On July 17th, they responded to Jukin's letter. July 25th, Jukin sent a letter to Equals 3's counsel with an attached invoice. This sounds very familiar, doesn't it? This sounds very, very familiar. Jukin argues that E3 never responded, never paid the invoice, never negotiated, so they went to a lawsuit. E3 asserts that May 1st, 2014, they filed at least 41 infringement claims with YouTube regarding Equal 3's episodes. Once such a claim is filed against an episode, Equals 3 can no longer earn advertising revenue from that episode. Additionally, once Jukin has filed a claim against the episode, Jukin can place advertisements. Okay, that's just how YouTube works. The parties agree that the fair use issue is ripe for adjudication and that this issue may be dispositive of the case. At the status conference held in February of 2015, the court set a briefing schedule. So we're going to skip over what summary judgment is. For our purposes, it means that there's no dispute over the facts that can be then put to bed here. As a preliminary matter, the court notes that Jukin does not submit any of the licensing agreements granting its rights to the subject video. Additionally, Jukin has only submitted copyright registration certificates for 2 of the subject videos. Now, what did we learn in 2019 about this? That would be fatal to Jukin's case now, wouldn't it? If Jukin only submitted 2 registrations, they could only sue on 2 videos, right? So that's a problem for Jukin now that they would have to address. They really, in my humble opinion, should work this out with MXO, assuming MXO is also willing to work it out, because it takes 2. It takes 2 to dance. The court notes that the records for these registration numbers indicate that Jukin is the claimant for the subject video and that it has the rights by written agreement. In response to Jukin's proposed statement of undisputed facts, which is part of summary judgment, E3 argues that it is unclear whether they've obtained the rights from the actual copyright owner and whether they have the right to assert copyright claims. That's the Right Haven case. They have to own the whole copyright, not just some right to sue. There is no such thing as owning part of a copyright. At least not. You can license part of a copyright, but you can't just license the right to sue. E3 rests this argument on the Jukin chief executive statement in a newspaper article that the difficult part of the business for Jukin is finding the true owners of the videos it targets for acquisition. Regardless, the court assumes, as argument for this motion, that Jukin has validly obtained the rights to the videos at issue, including the right to assert claims, and solely for the purposes of this motion, they assume that each of the E3 complained of episodes actually made use of one of Jukin's videos. The fair use doctrine has been called the most troublesome in the whole law of copyright. Yep, I think I can agree with that. What do you think, Joe? The fair use doctrine is the most troublesome of the law of copyright. I agree. I've spent 8 years studying this, and I'm still learning things on the daily. The Copyright Act provides that fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, research is not an infringement of copyright. They go over the fair use factors, the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the whole, the effect of the, or I'll call it the market usurpation factor. The factors are not treated in isolation. They must be explored and weighed. It's a balancing test. That's Campbell v. A. Cuff-Rose Music, a Supreme Court case. The Supreme Court found that the transformative uses lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright, because such transformative works generally further the goal of copyright, which is to promote the sciences and the useful arts, Article 1, Section 8, Clause 8 of the United States Constitution. Literally, this right is built into the Constitution. On to the first fair use factor in equals 3. The key inquiry for the first statutory factor is whether and to what extent the new work is transformative. A new work is transformative when it does not merely supersede the objects of the original creation, but rather add something new with a further purpose or different character, altering the first with new expression, meaning, or message. The more transformative the new work, the less will be the significance of the other factors. That may weigh against a finding of fair use. The preamble to Section 107, the Fair Use Rights, lists criticism and commentary as illustrative bases supporting fair use under this factor. The Supreme Court has stated that parody has an obvious claim to transformative value. Nevertheless, there are no bright lines. Fair use must be evaluated on a case-by-case basis by reference to the 4 statutory factors. That means every single time you make any use of something you do not own, you must conduct a full fair use analysis. This is why it's so expensive. This is why it is so tedious and why people run into problems. In that larger sense, let me make sort of a public service announcement. Like, I don't condemn either of these parties for having this dispute. Look at how difficult it is. Even the court says this is the most difficult thing in copyright. E3 asserts that its episodes are transformative because they are parodies of the Jukin videos. Jukin argues that E3 is not a parody because they do not critique Jukin's videos. According to Jukin, E3's episodes are at most satires of society or some other subject in general. A parody is a work that uses some elements of a prior author's composition to create a new one that, at least in part, comments on that author's works. Remember, I've said this, that I can use your video to make commentary on your video. That's transformative or that's fair use. But I can't use your video I can't make a parody of your video by making a video of me, talking about something else. So let's take I like the Weird Al Yankovic example. Weird Al often gets his licenses in order and actually licenses all the as many of the works as he can to make his new works, his redone lyrics and things. I'm avoiding using the word parody. In order to be a parodic work, he has to comment on the original in the new work. Not just a little bit, but it has to be the major thing in the new work. So eat it as opposed to beat it. Michael Jackson's Beat It versus Weird Al Yankovic's Eat It. If that's commentary and criticism of the original, then that's a parody. But if he just changes the lyrics, just make it a more funny song or a different song using that's not a parody and that's not a fair use. At least not all by itself. And that, all by itself by changing the lyrics. Maybe there'd have to be something more by using less of it or something. But in Weird Al's case, he's using the whole thing. He's doing the whole thing, just changing the lyrics. If that's all he does without making commentary on the original or critiquing the original, then it's not a parody and not a fair use. In contrast, satire has been defined as a work in which prevalent follies or vices are assailed with ridicule or attacked through irony, derision, or wit. Parody needs to mimic an original to make its point, and so has some claim to use the creation of its victim's imagination. Whereas satire can stand on its own 2 feet, and so requires justification for the very act of borrowing. Determining whether E3's episodes parody Jukin's videos is a difficult and nuanced task. As pertains to this case, Jukin's videos are typically short, point-and-shoot style depictions of events that actually happened. These events typically have an unplanned or spontaneous aspect to them, such as an attempted boat stunt failing or a child having an unexpected reaction to the news of his mother's new pregnancy. Jukin asserts that its video's purpose is humor and entertainment. It is difficult to say whether E3's episodes, which undisputedly use graphics and narration to tell jokes about the events depicted in the videos, criticize these videos, which were themselves made to serve the purpose of humor and entertainment? Or do they simply point out those videos' inherent humor? I think that's a really, really important sentence. It is difficult to say whether E3's episodes criticize Jukin's videos or simply point out their inherent humor. What is the creativity in pressing a button on a phone and pointing it in the right direction? These videos weren't necessarily productions that were set up. They're often just facts that actually happened, like the judge pointed out. It's not that that doesn't get copyright, but I'm going to say that's a really minimal copyright. You can't even say that someone played with the camera settings and lighting and setting and characters and plots and themes and all that. No, somebody saw somebody on a jet ski, pointed their phone at it, and the guy wrecked, and it was funny.
Is it possible that the Jukin is editing these in some way, or that's where they're doing the minimal creativity or putting a filter on it, adjusting lighting after the fact?
Could be. I mean, maybe that's a thing that they should do, but I don't think they're actually doing that. I think they're just licensing videos like Viral. I have 2 videos with Viral Hog, and they just licensed them from us. Nevertheless, even if Equals 3's episodes are not parodies, the episodes comment upon or criticize Jukin's videos. Equals 3's episodes directly respond to and highlight humorous aspects of Jukin's videos. The episodes do so via the host's reactions to the videos. Jokes, narrations, costumes, and graphics. The host's narration does not simply recount what is shown in Jukin's videos. Instead, the host makes comments about the videos that highlight their ridiculousness by creating fictionalized narratives of how the events transpired, using similes, or by directly mocking the depicted events and people. Equals 3's episodes also repeat portions of Jukin's videos multiple times within the same segment. For example, E3's episode entitled The Resurrection uses part of Jukin's video Black Bear Milk Jug Rescue. Jukin's video shows, among other things, footage from a distance of a bear in a field. At least 3 attempts by a tractor's crane to grasp the milk jug on the bear's head, and then the crane successfully clasping and removing the jug from the bear's head, and the bear running away. I mean, that's hilarious. That's the thing that actually happens. I thought that was a thing out of like cartoons. It's that thing that actually happens, apparently. I'm just laughing at the thought of it. The resurrection shows, among other things, some shots of the crane next to the bear with the jug on its head, one unsuccessful attempt by the crane to grasp the jug, and then the crane successfully grasping and removing the jug, and part of the footage of the bear running away. The host makes such comments as, playing the crane game at Chuck E. Cheese's wasn't a waste of time, and compares using a crane to removing a jug from a bear's head to fishing with a hand grenade. The Equals 3 episode, Drunk Babies, uses part of Jukin's video, Groom Drops Bride. Drunk Babies shows Jukin's video of the groom running while carrying his bride, tripping and falling on her. Drunk Babies shows the footage of the actual trip and fall multiple times with different graphics and commentary interspersed. The host makes such comments as, "Shit, he literally body slammed his new bride," and describes the incident as an example of why you shouldn't wait to have sex until marriage because you get way too excited. Alright, that's pretty funny. In plain terms, whether or not E3's episodes criticize Jukin's videos, the events depicted in Jukin's videos are the butt of Equals 3's jokes. Thus, the jokes, narrations, graphics, editing, and other elements that E3 adds to Jukin's videos add something new to Jukin's videos with a different purpose or character. So this judge does agree that comedy can be at least partially transformative. This is not a case where the addition of minimal narration, an introduction, or text did not change the essential character of the original work. They cite to a couple different cases. This is also not a case where Jukin's videos are used to get attention or to avoid the drudgery of working up something fresh. Equals 3's use of Jukin's videos is admittedly commercial. Nevertheless, the commercial nature of the use is outweighed by the episode's transformativeness. Wait a minute, I thought the commercial use was the second factor. Did we skip into the second factor here, Judge? Hang on a sec. One exception to the aforementioned analysis is Equal 3's episode entitled Sheep to Balls. Sheep to Balls uses Jukin's video of the first person to buy an iPhone 6 in Perth dropping the phone. According to Equals 3, it used this footage for the purpose of making 2 points. Don't be first at shit, and Apple's method of packaging iPhones at the top of the box is absurd. It is, actually. You open it up and it can fall right out. Equals 3 thus admits that its purpose of using Jukin's video was to make 2 general broad points that were not directly aimed at criticizing or commenting on the video. The use of Jukin's footage to make these 2 points is akin to using news footage without adding anything transformative to what made the footage valuable. In this case, a clear view of the first person to obtain the iPhone in Perth dropping the phone upon opening the package. Finally, the court does not find that Equals 3's purported bad faith in not obtaining a license mitigates against fair use. If the use is otherwise fair, then no permission need be sought or granted. If using a song after requesting and being denied a license does not show bad faith, then neither does failing to obtain a license and continuing to use footage after being sent a demand letter. For the aforementioned reasons, the court finds that Equals 3's episodes are highly transformative. Not even partial. I said partially. The court finds they are highly transformative, and we're saying that MxR is doing something very similar to that. So this is very similar to the MxR situation, I think. Maybe we'd have to see the Equals 3's video to see if they're really as transformative as MxR or vice versa. But it seems to me like Jukin's own case is a good example of how MxR's videos are and could be considered transformative. Let's continue though. The nature of the copyrighted work, whether it's creative, whether it's unpublished, whether it's commercial, here it is undisputed that Jukin's videos were all published before =3 used them. It is more difficult to determine the extent to which these works are creative. The Ninth Circuit has recognized that a point-and-shoot photograph is not on the same level as the works of famous photographers. Nevertheless, the Ninth Circuit has also found that just because a photograph documents an event does not turn a pictorial representation into a factual recitation. So you can't say they're not copyrightable, they just have less copyright protection. So on the fair use factor, it should weigh less. Here, the largely point-and-shoot videos do not exhibit the same cinematic masterpiece of many famous film directors. Nevertheless, the court cannot say that they mainly convey factual information. Thus, the court finds that the nature of Jukin's works is creative. Nevertheless, the copied work's creative nature is not particularly important, where the new work is highly transformative. Thus, while this factor favors Jukin, it carries only slight weight. The third factor looks to the quantitative amount and qualitative value of the original work used in relation to the defendant's justification for the use. Jukin does not argue that E3 uses its videos in their entirety. Instead, Jukin complains that =3 takes the most important parts of its videos, their heart. The Supreme Court has recognized that a parody may need to take a work's heart in order to conjure up the original and achieve its parodic purpose. E3 asserts that it uses no more of Jukin's videos than is necessary to achieve its purpose of criticizing and commenting on Jukin's videos. The court agrees. Though =3 uses the arguable heart of Jukin's videos, it does not show more than is reasonably necessary to convey enough of the events to allow the host's jokes, comments, and criticisms to make sense to the viewer and resonate. The court finds the third factor favors fair use. This is so far undoing Jukin's point about it being not a fair use. Now I'm starting to fall firmly on the side of MxR being a fair use. But
I'm very surprised by that last analysis on that part. I would have thought that the heart of this would have been the comedy, which is what they're using, but it sounds like the judge here thinks this is still...
Yeah. I mean, reasonable people could disagree, and who knows, you're not going to get the same judge, at least not you can't count on that. So different judge could fall differently on this analysis and still be within their discretion. The fourth factor looks to the effect of the use on the potential market for or value of the copyrighted work. This inquiry requires courts to consider both the extent of the harm caused by the alleged infringer and whether unrestricted and widespread conduct of the sort engaged in by defendant would result in a substantially adverse impact on the potential market for the original. This is what I call the market usurpation factor. Well, I'm sure others call it. I'm only calling it that because others called it that and I learned from them. I'm not saying it's my thing. I'm just calling it the market usurpation factor. This inquiry must include harm to the market for the original and harm to the market for derivatives. However, the law does not recognize a derivative market for critical works. Market harm caused by effective criticism that suppresses demand is not a cognizable legal claim. Instead, the only kind of harm cognizable is market substitution, market usurpation, where the new work diminishes demand for the original by acting as a substitute for it. Thus, where a work is transformative, market harm may not so readily be inferred, and there is no presumption of market harm. Jukin argues that the market for its original videos is harmed, because E3 frequently copies its videos during the time when they are most valuable shortly after their publication. In support of this contention, Jukin offers the declaration of Ms. Smith, its Vice President of Content Operations. Smith gives no foundation upon which she bases her speculative conclusion. She simply makes the conclusory assertion that Jukin's videos are generally most valuable within the initial days and weeks after the first public. Okay, they are generally most valuable. But yeah, you'd want to back that up with showing the, the blip, showing that initial popularity and then the long tail. Once in a while, though, a video becomes popular afterwards. That's sort of what we count on. I'd say a good third of our revenue comes from past videos being watched more, as much, if not more sometimes, than our current videos. Smith also acknowledges that sometimes an older video becomes more popular only after Jukin promotes it. Smith gives no specific facts regarding the value of those videos at issue in the case before or after equals 3 used them. Moreover, even assuming, for argument, that the videos are more valuable shortly after publication, focusing on harm from equals 3's failure to pay a license risks circular reasoning. If equals 3's use is fair, then no license fee is required. Jukin further argues that E3's episodes usurp demand for Jukin's videos. In support of this argument, Jukin offers evidence that it licenses its videos to shows which it claims are similar to equals 3's. I'll get it right. However, as stated above, there is no cognizable derivative market for criticism, thus Jukin's argument fails to the extent that Jukin claims harm to a licensing market for shows that critique and mock its videos in a manner that equals 3's does. Nevertheless, the court must still consider the possibility that E3's viewers use the episodes as a substitute for Jukin's. Jukin claims that viewers no longer need to watch its videos after watching equals 3's episodes. E3 claims that its episodes actually increase Jukin's videos' views. Neither side submits evidence strongly supporting its position. Jukin submits no admissible evidence showing that a single viewer actually watched E3's episode instead of Jukin's video, or any instance when it lost a deal to license its videos. Instead, it relies on Smith's unfounded testimony that E3's viewers no longer need to watch Jukin's videos. Jukin also relies on the conclusory statement of its director of licensing, Mr. Digden, that equal 3's use of Jukin's videos decreases their licensing values. However, Digden's only support for this statement is that, for instance, a potential licensee is less likely to license a video if they think others are copying it for free. Equals 3's use of Jukin's videos contributes to a culture of infringement and gives the impression to other potential licensees that they do not need a license to use this content. Dignan fails to offer sufficient foundation to support this broad, unsubstantiated statement. Hey, Joe, do you think maybe we're learning from this case that companies like Jukin need to do a better job of substantiating their losses in court?
It really can't be that hard to go find someone to say that, yeah, I didn't want to, some consultant who will say, yes, here's the actual facts that back up these statements. I mean, some of these things, it's like, yeah, they could have substantiated this stuff.
It almost seems like Jukin isn't really that prepared to take these things to court for how strong they come on requesting licensing fees. To support its position, E3 relies primarily on its employees' inadequately supported testimony and unauthenticated statements, purportedly from E3's viewers, to show that its viewers also watch Jukin's videos. So neither party was ready to present very much evidence of this. They speculate that when one of its viewers wants to rewatch a particular source video or share it on the internet, the viewer will likely go to the original source. Equals 3 also submits evidence that there is no way for one of its viewers to share a source video contained in an E3 episode without having the recipient watch the entire E3 episode. E3 fails to submit admissible evidence defining the relevant market.
Well, it's wild speculation to not have anything to back it up with.
Both parties here, right? Everyone's saying, yeah, well, less license fee, no damage. Okay, evidence? No.
Not a thing.
While the transformative nature of equals 3's videos, it's just so hard to say, equals 3's. While the transformative nature of equals 3's videos makes cognizable market harm less likely, the court cannot say that it is completely implausible that at least some viewers would substitute Jukin's videos with E3's videos. Both videos are meant to be humorous, and the court can imagine a fine line between the demand for the humorous original and the humorous new work commenting thereon. Nevertheless, there's no evidence of any such harm. And as discussed above, E3's episodes do not take excessively from Jukin's videos. Thus, on the record, where any market harm remains hypothetical, the court finds this factor does not favor either party.
Yep.
The court then weighs the 4 factors. In so doing, the court notes that transformative works generally further copyright's goal of promoting the arts and sciences. Here, E3's episodes, except Sheep to Balls, are highly transformative and use of Jukin's videos only what is necessary to achieve their transformative purpose. The first and third factors strongly favor fair use. There is no proof of cognizable harm to the market. The fourth fair use factor favors neither party. The second factor weighs against fair use, but it is of little weight in light of E3's episode's transformativeness. Moreover, Jukin's videos were published before E3 used them, so they're not unpublished. Thus, on balance, the factors weigh in favor of fair use for all episodes except Sheep to Balls. Wow. So then they say Sheep to Balls is not transformative and is likely to cause market harm. Thus, Sheep to Balls does not make a fair use of Jukin's video, first person to buy an iPhone 6 in Perth drops it on live TV when pressured by reporters. For the aforementioned reasons, the court grants in part Jukin's motion for summary judgment and denies all other aspects of the motion. And that's Stephen Wilson, United States District Judge for Central District of California. So holy mackerel, I think that undoes a lot of what Jukin just said on Twitter, right? They actually gave us a case to look up, and that case went against them. Well, the Legal gave us a case to look up, and Jukin Media pointed out that, yeah, we've got a great fair use case. No, you don't. You have a great case saying that what MxR does is either a fair use or is very close to a fair use. And maybe you don't want to get another one of these things against you and have to settle it on the eve of trial. Why don't you all just work it out? Imagine getting precedent on this in favor of someone like MxR, and then that opens the floodgates that anybody who was wondering if they can do that and why MxR doesn't get in trouble for it now knows that they can't get in trouble for it. And now, with a case like this, maybe MxR might watch this video or read this case and talk to their attorneys, not just make a whole bunch of assumptions, but maybe they can come up with a content policy that won't violate copyright and will be a fair use. Or maybe, honestly, I mean, we do this too. Why don't you just why don't you work out a license fee that everybody can afford and makes everybody happy? I don't know if it's $50 per clip or something. Maybe they can figure out a $2,000 per year fee or something. Maybe that's a little bit too low for Jukin, but maybe they can figure out a couple $1,000 fee per year, and then a very popular channel like MxR Plays can just go do what they'd love to do and not worry about the implications, not worry about the copyright claims that are going to come. Because even when they're right, they're still going to get claims like this. Eventually, it's going to happen again. When you're popular, when you're using others' content, eventually someone is going to come along.
And to be fair to Jukin, they're providing a valuable service here. They are clearing the rights for all of these videos, right? So if you pay the licensing fee, you are going to get cleared rights to use it how you want to use it.
Yeah.
You won't have to do a fair use, a fair use analysis every single time without a license. So, I mean, they are providing a value here that, is still meaningful.
I think so.
For a creator like MxR, yeah.
I don't fault Jukin for doing what they're doing. I know that a lot of internet people don't like companies like Viral Hog and stuff because they have to they work on enforcing their copyrights. I don't like the way Jukin went about this, but it's also not illegal. It's normal for a company to be aggressive about pursuing legal demands when they have a genuine good faith belief. And if Jukin does not have a genuine good faith belief, then they're on the wrong side of the law. But if they have a genuine good faith belief, then there's really nothing legally, ethically wrong with pursuing claims and being a bit aggressive about it. I disagree morally with the idea of we're going to strike the heck out of your channel if you don't pay us a license fee. I think this is just about money, and I think striking someone's channel, that's an intentional act, and they could just sue them for money damages and let everything remain up on YouTube, let everybody keep working and making a living, instead of using this strong-arm DMCA tactic. That I disagree with, and I disagree with it even more now that I've read their very own case, which says that =3 was making a fair use in the 2 example videos. Oh, and that Jukin didn't register the copyrights in 17 out of 19 of their videos that they sued over. Now they have to. Now, Fourth Estate Public Benefit Corporation says you can't even get into court without, well, you can get into court. You can get dismissed on a motion to dismiss by not having your copyrights registered before you sued. You don't just have to file the application and then sue. You have to actually have the granted application in your hand before you can sue. So they should be registering them if they plan to enforce them in court. But if they didn't register them, then they only get actual damages, which is $49 per video, apparently. So that's what we're talking about. We're not talking about millions of dollars. We're not talking about hundreds of thousands of dollars. We're not talking about tens of thousands of dollars, except maybe attorney's fees. We're probably talking about hundreds to a low $1,000 of licensing fees. And Jukin is talking about ending MxR's career over that. I think that's the immoral part of this, and maybe even a little bit unethical. I think a couple other attorneys pointed out unfair business practices might apply to this. I don't practice in that area, so I'm not exactly sure, but that sounds like a really good thing to explore. So yeah, so I like that analysis that the judge did, and I think that tells us a lot about what MxR could expect if they took their content generation to court with Jukin Media. And Jukin Media should then be much more careful about their fair use analyses, because every MxR video that makes this commentary and criticism in a humorous way seems to be a fair use, and only where they don't make any commentary, don't make any criticism, and just play a video, or somewhere where they're in between and it's on the line, those are the things where you could probably sue over. And why? Why? If your license fee is $49 and you haven't registered your copyrights, which I don't know if they registered their copyrights or not, I'm not speaking for them, but you should go look it up if you are using their stuff, or if you are trying to figure out what the damages are in a case, or whether you should sue them or not, or whether you should going to be sued by them or not. That's all stuff you should look up. But if they aren't registering their copyrights, then what are they doing sending these kinds of demands and making these kinds of threats? They should rather try and work it out. And that's our show, everybody. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Thank you to the following $50 supporters in the month of January. Thank you to Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Steven, Cute Grills in Your Area, and Ottah. And thank you to the $5 plus supporters who are scrolling on the screen in front of me. I love you all. I'll let you go. This was a long one. I'm Leonard French, your favorite copyright attorney. I'll see you in the videos that drop. Love you all. Bye.